Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court set aside anticipatory bail granted to 4 accused including a former DGP in a case of the alleged frame-up of scientist Nambi Narayan in the 1994 ISRO espionage matter. The court has remanded the matter back to the Kerala High Court for fresh consideration and asked it to decide it as early as possible within a period of 4 weeks. A bench of Justice M.R. Shah and Justice C.T. Ravi Kumar also granted protection from arrest to the accused for 5 weeks as an interim arrangement till the High Court decides the matter. The Supreme Court Division Bench, comprising of Justice B.R. Gavai and Justice B.V. Nagaratna, has observed that courts at the referral stage can only interfere when it is manifest that the claims are ex facie time-barred or dead, or there is no subsisting dispute. Another division bench of Justice A.S. Bopanna and Justice P.S. Narasimha observed that interpretation of contracts concerns the discernment of the true and correct intention of the parties to it. Words and expression used in the contract are principal tools to ascertain such intention. Noting that courts cannot become a town planner or chief engineer, the Supreme Court has stayed the Andhra Pradesh High Court's March order and directed the state government to develop Amravati as the state capital within the next 6 months. The bench was hearing an appeal filed by Y.S. Jagan Mohan Reddy government against the High Court order that had stalled its 3 capital plan for the state. The Apex Court has issued notice to the Centre and other on plea seeking to treat petitioners who have been working with the Ministry of Defence for the last 24 years as regular loaders in the Indian Army and extend them all the benefits which are being given to the regular appointed loaders discharging for identical work. A bench of Chief Justice D.Y. Chandrachud and Justice P.S. Narasimha issued notices in the petition stating that the petitioners have been working for 353 days in a year and have been working for the past more than 24 years. However, they are still being treated as daily wages. The Supreme Court has opined that unless the findings of the Departmental Inquiry are patently perverse, grossly incompatible with the evidence on the record, or the principles of natural justice are not followed, courts should not interfere with the decision. It was further expounded the disciplinary authority has the discretion to award punishment considering the gravity of the offence. The High Court or tribunal, while exercising powers of judicial review, cannot engage in reappreciating evidence to arrive at its conclusion. Unless the punishment is so disproportionate to the offence that it shocks the conscience of the High Court or the tribunal, they are not allowed to interfere with the findings. Next we have Delhi High Court. The Delhi High Court has stayed the circular issued by the Shahdara Bar Association of Karkarduma Court prescribing a new dress code for the law interns. The order came on a petition filed by a second-year law student challenging the circular. The circular was issued last week mandating interns to wear white shirt, blue coat and trousers. The Delhi High Court, while declaring ITC restaurants Bukhara as well-known trademark under Trademarks Act, has observed that not only the mark has been intrinsically connected to the Indian cuisine, but the plaintiff's restaurant has been recognized internationally as a customary stop for foreign celebrities and dignitaries. The single-judge bench of Justice Pratibha M. Singh has directed the registrar to add it to the list of well-known trademarks upon completion of requisite formalities. The Delhi High Court has observed that to decide jurisdiction at the initial stage, the courts only have to see whether the plaintiff discloses the cause of action within the territorial limit of that court or not. The courts cannot qualitatively examine the merits of the statements made in the plaint. It was opined by the bench that the application under Order 7, Rule 10 of the Civil Procedure Code 1908 has to be considered on demeanor, that the averments of the plaint has to be assumed as correct. The Delhi High Court, while observing that powers under Section 313 of the Criminal Procedure Code are wide enough so that the courts can recall a witness if it is necessary for a just decision, dismissed one application where the victim suffered 50% mental disability. It thus added that wide powers has to be used cautiously in light of the facts and circumstances of the case. The single-judge bench of the Delhi High Court has held that the core arbitration agreement does not perish when the procedure for appointment of arbitrator at the hands of one of the parties became legally invalid. It further opined that an arbitration agreement may narrate and include several other aspects relating to arbitration to detail out the arbitral mechanism and to make the arbitration agreement more comprehensive. Now let's have an overview of other high courts. The Kerala High Court in one custody case has reiterated that children have the right to come to company of both parents and severing contracts with one parent snaps emotional and psychological bond. The division bench to this regard noted that even if the custody is given to one parent, the other parent must have sufficient visitation rights to ensure that the child keeps in touch with the other parent and does not lose social, physical and psychological contact with any of the two parents. It is only in extreme circumstances that one parent should be denied contact with the child, the court observed. The single judge bench of the Gujarat High Court allowed the condonation of delay of 600 days. The court interpreted the expression sufficient course liberally in view of the governing principle and held that the monetary constraint on the applicant due to valid reason is a sufficient cause for condonation. A single judge bench of the Uttarakhand High Court has reiterated that writ courts should not be approached as the first resort when an alternative and effectuous remedy is provided by the court. The Punjab and Haryana High Court has held that arrest not only deprives right of personal liberty but also causes mental agony, stress and tarnished reputation of the entire family. The court observed that right to personal liberty guaranteed by the Article 21 of the Constitution is one of India's most pious and important fundamental rights guaranteed. A petitioner posted fake news about her employment on social media and the Bombay High Court, while awarding interim maintenance to her, opined that even if the conduct of the petitioner is not completely free from blemish, the courts cannot shut doors on her. It was further held that the mere fact that the petitioner possesses qualifications cannot ipso facto be a ground to deny interim maintenance. The court created a distinction between capacity to earn and earning and held the presumption that because of her education qualification, petitioner must have secured the job is erroneous. Moving on to miscellaneous news. The National Consumer Dispute Redressal Commission has directed the India Today Group, publisher of the iconic magazine Reader's Digest, to pay a compensation of Rs 1 lakh and the litigation cost of Rs 50,000 to a Punjab-based senior citizen for the late delivery of the periodical. Asserting that search and seizure of digital devices during probes further legitimate state interest and cannot be said to be violating privacy rights, the Union government has told the Supreme Court that common guidelines on preservation and handling of the information stored on the digital devices confiscated by investigating agencies across the country will require a consultation involving all states. Singapore Airlines and Tata Sons have announced that they have agreed to merge Air India and Air Vistara, with SIA also investing Rs 2,059 crore in Air India as part of the transaction. Gangster Goldie Barar, alleged mastermind of the musician Sidhu Moosewala murder, has been detained in California, US, Punjab Chief Minister Bhagwant Mann confirmed in a press conference. He further informed that Goldie will be extradited to India and that central agencies are in touch with authorities in the US to get details on him. The Supreme Court, which is hearing a challenge to the Tamil Nadu law allowing Jallikattu, has asked the state government how is the bull taming sport necessary for preserving the native base breed of bulls. A public interest litigation has been moved in the High Court of Delhi against making payments of salaries to imams, maulvis and others of the masjid across Delhi. The petition alleged that the AAP-led Kejriwal government is in gross violation of Article 14 and 27 of the Constitution in making payment to the tune of crores to the Delhi Waqf Board for payment of salaries to imam, maulvis and other of masjid across the Delhi. On the other hand, the pujaris of the temple across Delhi are not paid any remuneration. The non-payment of salary to the pujaris and the priest violates Article 14 of the Constitution. The plea further reads. The Supreme Court has disapproved of Law Minister Kiran Rijiju's remark in which he reportedly said that the Supreme Court Collegium could issue notification for judges' appointment if though the government was stating over the recommendation. A bench led by Justice Sanjay Kishan Kaul asked the Attorney General K.R. Venkataramani that how the system will work if names will not be clear. Noting that names cannot be holded for too long, the bench remarked that it appears that the government is unhappy that the NJAS did not pass the constitutional muster. In the end, we have international news. A US Federal Appeals Court has unanimously terminated Special Master appointed for an independent review of documents seized from the former President Donald Trump's Florida estate. This has removed a hurdle in way of the Justice Department, as it had said that the review process would only delay the criminal investigation into the retention of the top secret government information. In an interesting instance, 18 Indonesian non-governmental organizations have launched legal action against the government as a disagreement over endangered orangutan numbers escalated into a broader rebellion against curb on academic freedom. The groups have submitted a legal objection letter to the Ministry of Environment and Forestry over undermining independent scientific research in Southeast Asia's biggest economy. The Asian diaspora in North America is calling to reclaim the swastika as a sacred symbol after laws banning its public display started to emerge. The Hindu faith symbol often gets confused with the Nazi hate symbol. These minority faith communities are being joined by the Native Americans whose ancestors used it in healing rituals. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box. And for weekly updates, like and subscribe to our channel.